Welcome to this module on standards and EU legal system. In this video, we will discuss how standards connect to EU law and what role they play in EU legislation. The relationship between standards and law is both complex and highly relevant. The key starting point is that laws are mandatory while standards are voluntary. Laws are adopted by representatives of the people, such as elected parliaments, while standards are developed by technical experts in organizations under private law, such as for instance ETSI. The voluntary nature of standards is recognized internationally. For example, the World Trade Organization, which oversees international trade, makes it clear that standards it covers are voluntary technical documents. That said, standards can still produce legal effects when they are referred in regulations. If you have watched other modules, you may already be familiar with the new approach, or as it was later called, the New Legislative Framework, NLF. This EU regulatory technique dates back to the 1980s. In short, NLF legislation sets out mandatory essential requirements, while three European standards organizations, the ESOs, CEN, CENELEC and ETSI, develop voluntary European harmonized standards that can be used to demonstrate compliance with these requirements. If those standards are followed, there is a presumption of conformity with European law. This system is based on a public-private partnership. Standards support legislation and policy, while responsibilities are clearly divided between the legislator, namely the European Commission, and the ESOs. The most important legal instrument of the NLF is EU Regulation 1025/2012, which establishes the legal framework for EU standardization. Article 2 of this regulation provides definitions. It makes clear that the standard is a voluntary document and that compliance with it is not mandatory. It also distinguishes between different types of standards: international, European, harmonized and national standards. This distinction is important. ESOs produce many deliverables, but only harmonized standards trigger a presumption of conformity with the essential requirements of EU legislation. The regulation also sets rules for how ESOs and national standards bodies, the NSBs, operate. It imposes transparency obligations, such as requiring ESOs and NSBs to publish their annual work programs. The regulation also emphasizes stakeholder participation in standardization, particularly for SMEs, consumer organizations, and environmental groups. These so-called Annex III organizations are eligible for dedicated funding under Article 16 to support their participation. A very important rule is the so-called standstill obligation. NSBs may not publish or maintain national standards that conflict with harmonized standards, even when such harmonized standards are still in development. If conflicting national standards already exist, they must be withdrawn. This ensures that harmonized standards prevail across the EU and prevents fragmentation of the internal market. It should also be noted that harmonized European standards are distributed through national standards bodies. The internal governance rule of ESOs and NSBs further define their operations. Regulation 1025 also defines the roles of different stakeholders involved in European standardization. The European Commission drafts requests for ESOs to develop harmonized standards. ESOs must respond within 1 month to accept or reject the request. If accepted, they receive EU funding under Article 15 and begin the drafting process. Once a standard is prepared, the NSBs vote on its acceptance. The Commission then, assisted by house consultants, verifies whether it meets the requirement of the request. If it does, the Commission publishes the reference in the official journal of the European Union. This is where the EU legislation, case law and decisions are published. In short, the Commission requests a harmonized standard, verifies its compliance with the requirements of this request, and publishes the reference to a standard in the official journal of European Union. The ESOs accept or deny the request, conduct the technical work on a standard through NSBs and other stakeholders, and NSBs approve the draft of harmonized standard. EU member states also have a role to play. If a member state believes a harmonized standard does not meet essential requirements, it can file a formal objection under Article 11 of the regulation. The Commission then decides whether to publish the reference or whether to revise the standard. The regulation emphasizes that standards are voluntary. Yet the Court of Justice of the European Union has held in the James Elliott case that harmonized standards are part of EU law and can produce legal effects. This has been confirmed in the following case law of the Court. In the most recent case, the European Court once again confirmed that the legal effect of harmonized standards make them essential tools for economic operators, and also held that such harmonized standards should be disclosed under EU regulation on public access to documents of European institutions. Moreover, some standards are referenced in national legislation. While EU rules harmonize the system to a large extent, such national references would typically fall under the administrative law of EU member states. To conclude, as it currently stands, the EU legal system draws a clear line between laws and standards. Standards are voluntary, yet harmonized European standards create a presumption of conformity with legal requirements and therefore have legal effects. Legal rules on EU standardization, including the requirements and rights of different stakeholders, can be found in EU Regulation 1025/2012. Different actors, the Commission, ESOs, NSBs, and EU member states, all play specific roles in making the system work. Thank you for listening.